Hello, wonderful attendees. I'm your host, Dalvinder Kaur from Lovely Professional University. Get ready to dive into today's topic, that is exploring the delivery of justice through the prism of ADR mechanism and legal aid tools. Before we proceed further, allow me to introduce the experts of the day. Dr. Yugdeep Kaur, Associate Professor and COD, School of Law, Lovely Professional University. She holds a PhD and LLM in Constitutional Law from Punjab University, Chandigarh. Dr. Kaur is a prolific researcher and presenter in her field. So now I would like to introduce Advocate Ravish Malhotra, Punjab and Haryana High Court, with the 20 years of experience, currently serving as the additional standing counsel for the Government of India in Jalandhar. He specializes in civil and criminal cases and has extensive experience with legal audits and documents vetting for banks also. And now I would like to introduce the admission nominee also in this webinar, Mr. Rishabh Sharma, Officer and Area Coordinator at the Department of Tie-Ups, Division of Admission, Lovely Professional University. Mr. Sharma plays a pivotal role in connecting the university with various institutions and organizations. Before we proceed further in today's session, I would like to request everyone for any questions. You can write in the chat box or in the Q&A box. And same will be addressed from my side in the end of this webinar. And now I hand over the things to Dr. Yugdeep and Advocate Ravish Malhotra, and it would be an absolute delight to listen from them. Over to you both.
Thank you, ma'am. And a very good afternoon to all present here. I'm very happy that I have got this opportunity to present on the present topic through the platform of Lovely Professional University. And first, here in these two topics, we have very sensitive points with us. One is that of free legal aid in India, and the second is that of alternative dispute resolution mechanism in India. So for this, first, I would like to give you a brief about these two topics with the help of a PPT, and then I will would request the sir to give his insight on these two topics. So let's start with it. I hope that my PPT is visible to everyone.
Yes, ma'am. Screen is visible. You can continue.
Okay, thank you, ma'am. So the right to free legal aid in India, we can see that many people in India, they are illiterate. They do not know about their basic rights, and it's very essential to let them know that what rights they have in their hands in the form of free legal aid in India. Because whenever we think of free legal aid, it is our constitutional remedy which is there. But the people in general, they are not much aware about these. Let me start with this, that what we have in our hands. So first, here the free legal aid, it is very much important for the weaker sections of society, the people who cannot represent themselves. And here specifically, the National Legal Services Authority, it is playing a very pivotal role in that. And the main aim of conducting these kind of webinars, it is that to make the general public aware about these rights. So legal awareness, it is the paramount consideration which is required to be done. So as we can understand from the word free legal aid, that means a person who is vulnerable, we can say, who is weaker in the society, that individual wants a special attention, and even their rights, they should be protected. We have Legal Services Authorities Act with us. So now you can see that legal aid is the provision of assistance to people otherwise unable to afford legal representation and access to the court system. It is not everyone's task to get that involved in the legal that things, and it's a big challenge for the people. So right to have counsel, equality before law, right to a fair trial, these are the requirements which one requires. And for this, we can understand the meaning of the term legal aid. So one by one, I'm going to take first when we talk about the equality before law, as we all know that everyone is equal in the eyes of law. No one is better than other. Law is giving equal opportunity to everyone. So that is our fundamental right as well, which is there in the Indian Constitution. And treat everyone equally. That is very important. Any kind of discrimination, it should not be there on the basis of race, gender, color, origin, religion, disabilities, anything, right? Then equality in the eyes of law. Everyone is equal in the eyes of law. So now what the person gets through the free legal aid, representation through a counsel in the legal proceedings. So herein, the government will appoint the lawyer for the parties, whosoever are involved, and then this is the way of acting. Now, that one very much required thing, even we have many case laws with us, even sir will agree with on that particular point. And for that also, we will discuss. Now, right to a fair trial. That is the very much requirement that independent, impartial trial, it should be conducted. And then, as I think now everyone would be known to this thing that why we need legal aid. We need legal aid because justice, it is equal for everyone, and we should always ensure that justice, it is done to everyone. And that could be done through this platform of free legal aid. Now, the constitutional commitment, as I was talking about, we have Article 39A of the Indian Constitution, which is providing that the state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and free legal aid. It is a part of that. So that is the requirement. Now we have NALSA with us, and under the Legal Services Authorities Act 1987, it was constituted, wherein the weaker sections, they can get free legal aid, and even time to time, lok adalats, they are organized for amicable settlement of disputes, because the correlated topic for today, we have that alternative dispute resolution mechanism with us. So one very important point which you can see from my presentation, that who are the eligible persons for this? Women and children, members of SC, ST, industrial workmen, a victim of trafficking in human beings, and then victims of mass disaster, and mentally ill individuals, person in custody, and even more importantly, you can see that a person in the seat of annual income less than rupees 3 lakh. In the case, if the case is before the Supreme Court, then it is 5 lakh rupees. So this is the manner that how one can apply for this. Even online, it could be possible. And for more insight, I would request sir to give his viewpoint on all these points. So this is one case law on this, Hussain Ara Khatun versus State of Bihar, which is also a very, very famous landmark judgment. And Justice Bhagwati, he has given his observation on it, that it is the constitutional that every accused person who is unable to engage his lawyer, he is required to give that. With this insight on the term free legal aid, before starting my next presentation, now I would like to request sir to give his insights on the present topic in his own aspect. So now kindly, sir, I request you to please give your insights on this particular topic.
Thank you, madam. Thank you very much. This is a very important topic nowadays, as we all know. The basic purpose of this is that no one can condemn or having any right before law. Everyone is entitled to engage any advocate. Everyone is entitled to have right to get justice from the courts. If he is unable to engage any, one should be adoptive and one should be able to get the lawyer for himself. This is no criteria that I am financially weaker, I have no knowledge, I am unable to understand anything. This is no criteria. The purpose is that everyone has right. Everyone cannot be condemned that he doesn't know about the law. So every person get a chance to defend himself through lawyer. But this is not the criteria that I'm unable to engage any lawyer. I am financial weak. I do not know anything about law. What are the charges imposed on me by the police or the authority? That is why this concept has been introduced, that right to legal aid. As Dr. Yugdeep has already made the presentation, who is applicable, who is eligible for taking this legal aid help. Basically, the 8 categories have been mentioned, as already been described. Every woman and child means minor. One thing in this concept I would like to add, that the new concept which has been replaced the IPC, Bharatiya Nyaya Sanhita. Bharatiya Nyaya Sanhita 2023 has been replaced by IPC, and in that particular thing, the word minor has been abolished. Now they are using the word for minor is child. This is a new concept. So in this legal aid service, we will say that child means the person who is below the age of 18, because minor word has been abolished in the BNS, Bharatiya Nyaya Sanhita 2023. Every member who belongs to ST community, disaster person, industrial worker, the person who having the income below 3 lakh per annum in the states, and for the Supreme Court it is 5 lakh, as madam has already been described. So this is a basic concept for right to legal aid, that every person has right to defend himself, to defend his case. As we already know, the very famous case of the Kasab case. Even everyone, media trial has been initiated. We cannot go into the details of that. But lawyers have refused to take the case of Kasab, who attacked on the Tata Hotel at Bombay. Every lawyer has refused to take the case of Kasab, but only through the right to legal aid services has provided a lawyer free of cost to him. No, even he has the right to defend his case, whether he is guilty, proven guilty. Even then, he has right to defend his case through the legal aid cost. The panel of advocates is available in the legal aid office in every district, even in the tehsil also. That has been, the list of panel advocates are available. From those panel advocates, the member secretary, DLSA means District Legal Services Authority. The secretary is CJM of that particular district is the secretary, and chairman is the session district, and session judge is the chairman of legal aid, DLSA. He marks the case to the particular advocate from the panel list. So anyone, even the accused person who is confined in the jail has right to take the advantage of this particular facility, which has been provided by the government to every citizen or to every accused, to get the chance and avail the services of counsel free of cost. And I would like to add one thing more in this, that even the person who is availing the services of legal aid, right to legal aid, the service who is availing is not entitled to pay even the court fees from his pocket. Even the court fees of rupees 1 to lakhs has been paid by the government, has been paid by the District Legal Services Authority. So not even a single penny has to spend by any person who is availing this service, but he can take the services throughout the case. Thank you, madam. Over to you, Yugdeep, madam.
Thank you, sir. Now, as sir has given his insight on the topic of free legal aid and how one can get it, and sir has specifically mentioned about the District Legal Services Authority, And here I would like to say that District Legal Services Authority, it is playing a very important role, because as the panel advocates, they are available with the District Legal Services Authority, and from there the people, they can approach them, and they can get the legal aid free of cost. So this is one aspect on the topic of free legal aid in India. And one more important topic which we have in our hands, that is of the alternative dispute resolution mechanism system in India. This system, it is very prevalent nowadays. It is making its place in a very good manner. And now I'm going to give some insight about this topic of alternative dispute resolution system or mechanism, that what it is and what we have in our hands in that. And we have various mechanisms with us, and one by one I will discuss those mechanisms, and then I would request the sir. So here, as in relation to the free legal aid, I was about to tell about the Lok Adalat. Even I would request sir to give his insight on this particular thing, that Lok Adalats, they are very important. Why important? Because now let's correlate it with that of the topic of alternative dispute resolution system, because alternative remedies, they are there. Alternative remedies, obviously, why we need alternative remedies when we have the judicial system with us, formal judicial system, it is already present. Then what is the need of going for that? So even Lok Adalat will be one concept which I will discuss. So I'm again sharing one more presentation with everyone. I hope my screen, it is visible.
Yes, ma'am, screen is visible.
Whether my presentation it is visible or
No, ma'am,
not?
presentation is not visible.
Okay, ma'am. Wait. I hope that it is visible now.
Yes, the presentation is visible. You can continue, Dr. Meera.
Okay, okay, ma'am. Thank you. Now, this alternative dispute resolution mechanism in India, we have various methods with us. First of all, we need to know that why we need it. That is the point. Because what happens that in the formal judicial process, we face many challenges. That the ultimate aim of law is that the dispute, it should rest. That somehow we should not encourage disputes in that manner. We should now find out, we were in requirement to find out the alternative means apart from the formal judicial system. And that was the reason that apart from the traditional judicial system, we started following various other mechanisms, which are like mediation, conciliation, arbitration, and even Lok Adalat. So the need was that it is cost effective, it is flexible, it is efficient. So one by one, I'm going to shed light upon all these points. So I would like to start first with the mediation. Now, what happens that sometimes it is not possible for the parties to resolve the dispute on their own. No doubt, in alternative dispute resolution mechanisms, we are required to act. More importantly, the mediators, the arbitrators, the conciliators, they are there and they are playing a very important role in that. Now, what happens that these platforms, they are important. For mediation, you can see the mediator, he is a neutral, impartial person who will be acting and who would be facilitating the parties. Why I'm using the word facilitation? Because he is not imposing his decision on the parties. He is just giving them the solutions. He's just suggesting them the solutions in that way that the parties, they can come on the amicable resolution of the dispute. And in the similar manner, we have conciliators with us. But the role of conciliator, it is somehow different from that of the mediator, because he is somehow playing a bit active role in that. And for arbitration, we can see that the award, it will be binding on the parties, and the arbitrator, no doubt, he is required to be neutral, impartial towards the parties, and he will be giving his decision. Here you can see that arbitration, it is a private binding process where the third impartial person, who is the arbitrator, or even the panel of arbitrators, they could be there, and they will be hearing the case, and then they will be giving the decision. Now it is covered under the Arbitration and Conciliation Act 1996. And for mediation, I would like to add on one more thing, that we have Mediation Act of 2023 with us. That is very important to know about. The new change in the law, it is required to be known to everyone. So now, as I was talking about that, what is the requirement, what is the need of it? Time efficiency, it is required. It is obviously, if we are following these alternative means, then they would be resolved in a time-bound manner, and it will be cost saving, and it would be flexible. It is very easy for the parties to decide upon the persons who would be acting as mediator and so on. And one more thing which it provides, it's that the preservation of the relationship between the parties, which is not so as in case of formal litigation. And then arbitration, you can see in India, we have Act with us, Arbitration and Conciliation Act of 1996 is there, based on the ancestral model law. And then we have various institutional arbitrations with us, and so on. For mediation, practices, they are there. And now, as I have mentioned, that nowadays online dispute resolution, it is with every passing day, it is making its place a very good place in the law. That is there. And even judiciary is playing a very important role in case of ADR. Because what happens if I take the example of arbitration, in case of arbitration also, for the enforcement of the award, what we are required to do for the execution of it, we are again required to switch over to the formal judicial system, and therein how the courts, they come into picture. So that is there. For that, I think we need to go into more details of all the acts and all the proceedings which are there involved in those points. Now, as I was talking about the emerging trends and developments in the Indian ADR system, online dispute resolution, it is there, community-based mediation, it is there, technological innovations we are following. And so in that way, it is day by day, it is changing its face, I can say. So in the end, I would just want to end it up by saying that all these means, they are very essential for us. And why they are essential? Because even the parties who are involved in these, they somehow get frustrated through the long proceedings. More specifically, if I think of the civil disputes, civil matters. And these alternative means, they are providing a very good remedy to the parties. With their voluntariness, with their own wish, with their own will, they can become a part of it. And only this much I want to say. Now, I would like to request, sir, that to continue with the topic of alternative dispute resolution mechanism. Kindly, sir.
Thank you, madam. Thank you very much. As you have very perfectly and beautifully explained this concept, alternative dispute redressal system. As the name of this concept has already indicates that alternative dispute redressal system. It means the alternative system which settles the dispute. Normally, when any dispute arises between the parties, we say that we will see in the court. I will see you in the court. This is the normal concept. Now, this is the alternative dispute redressal system. Alternative system has been adopted for solving any dispute between two parties. So that is why it is called that alternative way to resolve any dispute between two parties without going into the courts, into the judicial manner. That is why they have adopted this manner, ADR system. As the perfect system for this is the arbitration. All the other means mediation, conciliation. One more system is the negotiation. Negotiation is also the way of alternative dispute redressal. But normally in the companies, in two disputes, in the international way, we perfectly adopt the arbitration. Because why arbitration? Because this is the binding process on the persons, on the parties. Whenever any award has been passed by the arbitrator under Arbitration and Conciliation Act 1996, that is binding upon both the parties. No one can deny that I cannot obey this order. I cannot follow this order just because it is passed by the arbitrator. In that particular stage, arbitrator is act as a judge, as a normal judge, in the judicial manner. So the award of arbitrator is binding upon both the parties. Suppose the person is a normal person who is generally appointed by both the parties with the consent of each other as an arbitrator. He is a normal person, he is unable to execute his award. When award has been passing, then after passing the award, that particular award can only be executed through court. In the execution process, and one more thing here, that award can only be executed by the judge at the rank of district and session judge. Either he is district and session judge or additional district and session judge. That award has been executed by that particular judge. Award of arbitrator can be executed by the district judge or additional district judge. Separate application before the district judge or additional district judge has been moved for executing the award has to be moved for executing the award. So that very much process is judicial process and binding upon both the parties, and most of the part of the world, not only in India, but most of the parts of world, the arbitration process has been adopted by most of the persons. The corporate sector, bigger companies, even the private sectors, they have adopted this particular process of arbitration for resolving any dispute. Second, we have taken the concept of mediation. Mediation is a wonderful process. When two persons are unable to talk with each other to resolve, no one is willing to go in the courts, but they want to resolve their dispute without going into the court. So they have adopted the method that one neutral person, one person can sit with us. We can discuss the matter. We can put our case. We can listen his case. Whatever the in-between way, middle way we can find out. That is the process of mediation by talking with each other. That is mediation when third person is doing some part of this. That is mediation. Now, one thing more for the arbitration I would like to add. When there is dispute between any two parties and no one is there as an arbitrator, then there is the process both the parties or any one of the party can go to the High Court for the appointment of the arbitrator. In that case, arbitrator is known as the umpire. When High Court appoints any arbitrator on the application of any party or joint application by the both the parties, then the person who is appointed by the High Court as an arbitrator is known as the umpire. In that case, High Court will appoint the person to resolve their case being an arbitrator. This is for the arbitration process. Similarly, conciliation. Conciliation is also very much similar to the process of mediation, because in this particular concept, one person tries to make them understand or resolve the dispute by sharing his views, by making them understand that we can solve this dispute by this way or that way. Just try to make the parties understand that we should not indulge in the disputes. So we have to resolve the dispute. In this way, one conciliator is there who tries to make the parties understand that we have to resolve the dispute. He can put his suggestions. He can give his ways that we should follow, that we can follow that particular way. It is upon the parties to obey the language, obey the words of the conciliator or not. Negotiation is also there. Negotiation is also the process when we used to negotiate with each other. Suppose if there is a case that, if there is a recovery case, financial case, one party is saying that I have to take rupees 50 lakh from the other party. Other party is saying that no, I have already paid rupees 25 lakh to that particular person. I am having that dispute. Let's negotiate on the accounts and settle the dispute. In between whatever the figure, yes, we have to pay only 10 lakh more, we have to pay 20 lakh more, whatever the in between the way. That is negotiation. And this is the best way. Why this is the best way? Because during this process, the relation between the parties always saves. And when we indulge in the court proceeding, when we indulge in the judicial system and any other way, there is the chances that they cannot get indulged or they cannot get sum up for having cordial relation in future. But by way of mediation, arbitration, conciliation, negotiation, there is a perfect chance to keep their good relations, to maintain the relation cordial with each other. This is the perfect way to resolve the dispute by the methods of alternative dispute redressal system. Thank you, madam. Thank you, Yugdik madam. Over to you. Dr. Yugdik Kaur, madam, over to you now.
Okay, okay. Thank you, sir. Thank you. Now, as sir has given his viewpoint about the alternative dispute resolution mechanism and various modes of it, here I would like to add one more thing that as sir has in a dispute, after spending so many years, the parties, they reach at a compromise. And then why that compromise stage, it comes so later? That is the point to think. Through the mediation, conciliation, these platforms, solve the dispute in amicable manner. And here in all these mechanisms, they are playing a very important role, wherein the mediator can make this thing realize to the parties that ultimately the compromise, ultimately to collaborate with each other, it will be a fruitful decision for everyone. Now, mediator, he will be taking the joint sessions, he will be taking the separate sessions wherein he can talk to the parties individually, collectively, so that he can make them aware that ultimately they are not going to get anything in the end. As sir has given the example that suppose one party is saying that they are ready to pay they are ready to go for that. Sometimes it happens that the parties on their own, they are not ready to resolve the dispute as they can resolve it through the help of mediator. So mediator, he is a person who is helping them out to reach on that particular solution. Question it is there from any one side, we can answer that question because sometimes it happens that the people, they have few queries with them. More importantly, with in relation to these two topics, they are very prominent ones. And even ma'am, if any particular question it is there in relation to that, if
Thank you so very much, Dr. Yugdeep Kaur and Advocate Ravish. So it was a wonderful discussion, a healthy discussion on legal aid tools. So now I would request to the admission nominee, Mr. Rishabh Sharma, to be on the screen. Over to you, Mr. Rishabh. Dr.
Thank you.
Yugdeep, can you please stop share your screen that admission nominee will able to share his screen. Thank you so very much.
Thank you. Thank you so much, Dalvinder ma'am. Yeah, just give me a second. Yeah, please give me a note that whether my screen is visible.
Yeah, your screen is visible. You can continue.
Thank you, ma'am. So before starting, I would like to extend my regards to the fellow panelists. So today we will be discussing about accreditation approval, uh, infrastructure part, extracurricular activities, and how you can actually check about the law programs, information related to that eligibility, fee structure, scholarship, and how you can apply for admission in LPU. So to start with, it gives me proud feeling to share with you all that now LPU is NAC grade A++ university with the 3.684 on 4-point scale. It is highest score in first cycle of accreditation among all of government and private universities. So if we move further, we also have approval from NCTE. We have PCI, Bar Council of India. And if you talk about membership, we are member of Association of Indian Universities, International Association of Universities. This is long. We have just added few of the slide. So if we talk about ranking and awards, LPU has been ranked 23rd under the World University Ranking 2023. Under World University with Real Impact, we have been ranked second. Under Atal ranking of institution on innovation achievement, we have been ranked third. If we talk about extracurricular activities, LPU student created history. 12 out of 13 LPU students won Olympic medals in all three categories: gold, silver, and bronze. LPU is champion of 37th Inter-University Youth Festival under the aegis of Association of Indian Universities, New Delhi. A student excelled in all the departments, whether it is literary, music, fine arts, dance, possession, theatre. LPU is also first runner-up for Maulana Abdul Kalam Azad Sports Trophy 2023, which was awarded annually by the Ministry of Youth Affairs and Sports. A student shined at 19th Asian Games. See the level of exposure at LPU. LPU successfully hosted 106th Indian Science Congress, which was inaugurated by Honorable Prime Minister of India, Shri Narendra Modi. His Holiness Dalai Lama at LPU campus. Two former presidents and single frame then President of Afghanistan, Mr. Hamid Karzai, alongside then President of India, Shri Pranab Mukherjee, alongside our worthy Chancellor, Sir Dr. Ashok Kumar Mittal, Member of Parliament, Rajya Sabha, then Finance Minister of India, Shri Arun Jaitley ji, Venkaiah Naidu ji, spiritual leader Gohar Gopal Das ji, many renowned faces keep on visiting LPU campus from time to time. You can just have a look. We have added few of the slides. LPU also hold one Guinness Book of World Record for officially attempting highest number of people doing Bhangra at a single venue. State of art infrastructure, Shanti Devi Mittal Auditorium with sitting capacity of around 2,500 people. Labs are there, library is there, Unimall is there. You can get all your basic and essential needs fulfilled here. Even gymnasium is there, bowling area is there. We also have 50-bedded hospital within the university premises. State of art. You can aerial view of lovely professional university, lush green campus, clean, green and safe campus, night view of LPU, ragging free campus. We also have indoor stadium facility where we have badminton, shooting range, basketball, volleyball, even squash courts are there. We also have Olympic size swimming pool within university campus, outside view of indoor stadium facility. Now let's go live and discuss about the programs. For that, you can note our website address, that is www.lpu.in. I'm repeating it for you, www.lpu.in. Once you go to our website, you just need to click on admissions. If you're 12th pass out student, click here. Otherwise, if you are looking for a program after graduation, click here. If you are looking for doctorate programs or after graduation program, you can click here. So I have already selected 12th, and under 12th our discipline is law. I have already selected under law. These are the two options available. I have selected BA LLB honors. So it is a 5-year program with 10 semesters. Eligibility says you need minimum 60% marks in 10 plus 2 with English as subject, subject to qualifying LPNet or CLAT or CUET. Any of these three you have to qualify to take admission into this program. So if we move further, if we talk about fees for this particular program, fees is 1,20,000 per semester, but in LPU, fees entirely depends upon the caliber of the student. So if you have, you can get scholarship up to 25%. That would be amounting to 30,000 rupees per semester. You can get scholarship on the basis of LPUness, your performance in 12th class, and there are other scholarships as well. You can get scholarship on the basis of CUET, CLAT, and then if you are board topper, you can get scholarship as well. Financial aid need-based scholarship is there. Defense scholarship is there. Orphan scholarships. Financial aid is there to person with certain disability. Financial aid to person with certain disability. Blind is there. If we talk about important dates, last date to take admission in this program with these benefits is 25th of June, that is today. Date of entrance exam is, it is being conducted daily from 5th June to 30th June. Last date to submit application is 3 days before the conduct of the exam. That means if you want to give your exam on 28th, you need to book your exam slot by today itself. And LPNS result will be announced within 48 working hours. Now, there will be a question in your mind that how actually you can apply for LPNS and admission. For that, you can simply click here on apply now. Otherwise, you can go to admission.lpu.in. I'm repeating it for you. Direct link is admission.lpu.in. Here you need to register yourself. Once you register yourself, you will get all your credentials through SMS and email. Once you log in, there you will find continue to LPNS application button. There you need to make click and pay LPNS fees. For boys it is 1,000 rupees, for female applicant it is 500 rupees. So once formality is done, test is done, take admission option is also will also be available in your this portal only. From here you can pay minimum 15,000 rupees and proceed for your admission. That 15,000 is not any extra amount, that is part of your program fees itself. So now if you want to connect with us through WhatsApp, please note the number, that is 985256900, 985256900. If you want to connect with us through live video counseling, you can simply click here and you can connect with our live video counselor through Zoom meeting. If you want to connect with our telecounselor, you can note the number, that is 01824 404 404. 01824 404 404. So I hope, Dalvinder ma'am, I have covered all the important points. So thank you so much for providing me with this opportunity to guide this student.
Thank you so much, Mr. Rishabh Sharma. And once again, thanks to Dr. Yugdeep Kaur and Advocate Ravish Malhotra. As we come to the end of this webinar, I want to express my deepest gratitude to our experts for sharing their valuable insights and expertise with us. Your presence, enthusiasm, and active participation have made this experience truly special. Hopefully, the attendees found this webinar to be valuable and will be able to utilize the information for better decision making regarding admissions. If anyone wants to access this webinar again, they can visit our website, that is lpu.in, or can be accessed on YouTube also. Stay connected with us for future webinars until we meet again. With the permission of my seniors, I would be signing off this webinar. Take care and goodbye. Have a beautiful day.
Thank you, ma'am. Thank you.
Thank you, madam. Okay.